We begin tonight with the continued fallout over that group chat security breach that is now in the courts. Late today, a federal judge heard arguments from a government watchdog group suing over Trump officials' use of the Signal app to discuss military attack plans. The judge issued what he called a compromise order, telling all Trump administration defendants to preserve all Signal communications from March 11th to March 15th. Meanwhile, Democratic and Republican senators on the Hill are calling for an inspector general probe into the group chat. Some members are even calling for a criminal investigation. But Trump's attorney general, Pamela Jo Bondi, doesn't seem to be that interested.
There should be resignations, and there should be an investigation either by the Defense Department IG, Inspector General, or by the FBI.
Is DOJ involved at this point?
It was sensitive information, not classified, and inadvertently released. And what we should be talking about is it was a very successful mission.
There is potentially here a violation of the Espionage Act, as well as the Federal Records and Presidential Records Acts.
Today, there are also growing questions about whether two Trump officials misled Congress in their sworn testimony about the group chat debacle. Tulsi Gabbard and John Ratcliffe were asked specifically if weapons, targets, or timing were mentioned in those text exchanges. We're now going to highlight every single mention of those items from the group chat while comparing them to what those officials said under oath.
Was there any mention, Ms. Gabbard, of a weapon or weapons system?
I don't recall specific weapons systems being named.
Did this conversation at some point include information on weapons packages, targets, or timing?
Not that I'm aware of.
In a hearing the very next day, both officials were pressed on the apparent discrepancy between the chat and their sworn testimony.
Do either of the directors want to reflect on their testimony yesterday in the context of what I just read?
My answer yesterday was based on my recollection or the lack thereof.
Less than 2 weeks ago, you were on a Signal chat that had all of this information about F-18s and MQ-9 Reapers and targets on strike, and you in that 2-week period simply forgot that that was there. That's your testimony?
My testimony is I did not recall the exact details of what was included there.
Messy. This kind of messiness appears to be part of a larger pattern. A German newspaper reports that it found passwords and cell phone data for some Trump officials online. And Wired reports that the Venmo contacts for National Security Advisor Michael Waltz were also available online. Joining me now to discuss all of this is retired Army Major General Paul Eaton and Leah Lippman, a law professor at the University of Michigan's Law School, my co-host on the Strict Scrutiny podcast, and the author of the forthcoming book, Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. So, General Eaton, what is your reaction to this security breach?
Melissa, thank you for having me on. It's pretty much on three levels. So you have the senior 19 or 20 national security architecture folks who are on a commercial app talking about very seriously classified or sensitive information. You have the National Security Advisor who invites, for reasons unknown to me, Jeffrey Goldberg, a very noted and terrific reputation journalist with The Atlantic. And then you have the Secretary of Defense, who repeatedly denies that providing information on departure times for weapon systems and arrival locations for weapon systems that would give an opportunity for somebody to frustrate that event, either killing the pilot or frustrating the operation. So it's this is about as egregious a mistake as I've ever seen.
Well, it's unprecedented, too. I don't believe we've ever had a security breach of this sort on a publicly available app. Am I correct?
I spent 33 years, and a lot of those years were before social media and the terrific technology that we have right now. The men and women on that Signal app, they knew better. They did it out of ease, out of comfort, to be able to do it from their home without having to go to a secure means of communication. So out of laziness, we had this security breach that has really taken down the U.S. reputation with our allies in a terrific sense.
So, Leah, the general alluded to this, but there are actual protocols in place for dealing with sensitive information of this nature. And we just heard Senator Blumenthal mention the Espionage Act and the Presidential Records Act. How do those specific pieces of legislation apply here? And what are the dangers for this administration in terms of the legal exposure because of those legislative enactments?
The Espionage Act limits the ability for federal officials to disclose classified or sensitive information, outside of secure channels. Of course, we know the fish rots from the head, Melissa, and we know the person in charge of the White House is not exactly super keen on protecting and preserving America's secrets, given that he was housing them in Mar-a-Lago bathrooms. So it's not entirely surprising that his Secretary of Defense would be throwing out bombing plans in a Signal chat. A little more surprising that he'd be doing so with the Atlantic journalist added to the Signal chat. The Records Act, as you noted, creates an obligation on agency heads as well as the archivist to preserve records that relate to an agency's policies, procedures, and decision-making. And obviously, they did not do that here. In fact, it creates an obligation on agency heads to actually tell the archivist if they have reason to believe that records are being destroyed or taken out of the agency. And here you have several agency heads on the Signal chat, including Secretary of Defense Pete Hegseth and Secretary of State Marco Rubio, I believe, saying that, they know this is happening on a Signal chat and it's not actually happening consistent with federal records.
So, General Eaton, the Defense Department has very clear rules about the handling of classified information, and the disclosure of significant military plans or intelligence operations are considered classified materials. And we've seen many of these officials who are on this group chat say over and over again that this was no big deal. There's nothing to see here. How, given those protocols, can they claim that they weren't violating rules and compromising the safety of national security information?
So, Melissa, when I was a colonel, I was in the Pentagon in the J3 current ops, and I literally feared speaking about anything that I was doing there lest I reveal a classified event or a piece of information. And so when people ask me what I did during the day, I just did not reveal anything. And that's as a 44-year-old colonel in the Pentagon. Every service member feels the same way, and we are loath to provide any information lest it be a revelation of a classified event. So we know what we're doing. The senior leadership, the senior civilian leadership of the national security architecture of the United States either does not know what they're doing, or they are lazy and are unwilling to do the right thing at the right time.
Right. Leah, Attorney General Pamela Jo Bondi was asked about the prospect of legal liability for the officials who are in this group chat. Here's what she had to say.
If you want to talk about classified information, talk about what was at Hillary Clinton's home that she was trying to bleach a bit, talk about the classified documents in Joe Biden's garage that Hunter Biden had access to.
So those aren't the first comparisons that I thought of. I, too, like you, thought of the Mar-a-Lago bathroom and the classified information that was retained there. But are these the right comparisons to be drawing here, or are there meaningful distinctions between Hillary Clinton and Hunter Biden's situation and this particular breach?
Yeah, that's a hard no on whether these are the same. This is literally the Secretary of Defense talking about possible bombing plans, right, involving precise weapons as well as targets that have not yet happened. Right? Imagine if that Signal chat had gone to a hostile foreign adversary, or imagine it had gone to someone who was not a patriot like Jeffrey Goldberg and would have sold that information to a hostile foreign adversary. These are impending military plans that is completely different than something Hunter Biden might have had on his laptop.
And so why then won't the Attorney General even entertain the possibility that there may actually be a criminal investigation and the prospect of legal liability for those involved in this?
Because the defining principle of this administration is law for thee, but not for me. After the Supreme Court effectively declared the president above the law with the immunity ruling last July, he seems to have imparted that wisdom to all of his political cronies and friends. The administration has suspended investigations and enforcement actions into companies that are affiliated with Elon Musk. And it seems like, they have also pardoned all of the January 6th insurrectionists. And they are also placing people within the administration above the law, basically saying we are not going to force you to comply with the law. And they feel emboldened to do so.